at least get the right foot in the door. And this is how it works. I think that this is kind of clever. The person will sit down at the computer or sit down next to somebody who knows how to run the computer, like a librarian. Librarians have been trained to do this, and we have about 13 sites in the state now where other people are available, near courthouses usually, where an indigent person can go in and say, I need help, I'd like to get on Michigan Legal Help. Let's say the person's being evicted from their home. So what the person does is to enter into the computer that their problem is they're being evicted and they want to fight the eviction. The computer then starts to ask them questions, simple questions. What's your name? Where do you live? And the circumstances of the situation in good plain English that can be understood. And the indigent person simply answers the questions. At the end of the questioning, all the person has to do is press the print button, and out comes the form or forms that the courts will want, and all filled out. All filled out so that the person, all they really have to do is sign their name and take it into the court. Also on the website is information about how the court functions with respect to evictions, for example. Basic stuff people need to know about the law. That's pretty understandable, about as much as anybody really would want to know if they're going to sit and read long enough. But Michigan Legal Help is a great asset for these indigents in the civil legal area who can't afford attorneys and who are regularly required to go to court for one reason or another. Something else that's being done these days that I think is very useful is that the state has finally, our state Supreme Court, has finally decided that there will be a statewide system to oversee the appointment of interpreters for LEP people. Here again, the devil will be in the details, but the whole purpose of the state Supreme Court's activities now is to make sure that we have some uniformity among the counties for the providing interpreters to LAP people and for training and certifying them at the state level. So that's a big step forward. Another thing that's being done, and this has been going on now for maybe 15 years, is that we're getting what we're calling specialty courts. And I give judges a lot of credit for this. Specialty courts are courts where the kind of person I was describing earlier, who doesn't fit, the shell-shocked vet from the war, or the person with a mental illness who's accused of a crime, probably not murder, not something, a really vicious crime, but a crime that could require the person to be put away, is set into a different track in the court. And it might be a veterans court. We have here in Leelanau County in the 86th District Court, mental health court. We have a sobriety court, a domestic violence court, and a veterans court. Now, how these work is kind of interesting because it's innovative. The judge sort of gives over some of his or her responsibility to a team. The team would be the judge, the prosecuting attorney. If it was a veterans court, it would probably be a social worker and probably a vet, someone who'd actually been abroad, been in the war, and could talk to the vet who's being accused of a crime in a way that the vet could relate to. And they work with the vet to try to get that person the kind of care that he needs, if it's care for drugs or care for violent behavior. And that person is required to keep coming back before the judge every few weeks, where a report is made while that person stands there about how well he's doing. If it's a sobriety court, it's a question of staying off the booze. And that person knows that he or she is going to have to come before the judge on a regular basis and be accountable for staying sober. The cost of not doing it, of course, is that the person is thrown back into the normal routine then of the criminal procedure and likely put away in jail or in prison. So Specialty courts are a real innovative step that's really been very helpful, and I think innovative for the courts. Let's see, what else have we done here I think over the years we've got what we call alternate dispute resolution centers. Have you heard of this? Almost everywhere now in Michigan, and certainly in Leelanau County, circuit judges will send a case to alternate dispute resolution to see if it can't be handled out of court. If it can't be resolved to the satisfaction of the complaining party in a way that doesn't require a lot of money and time by the courts. And there are controversies which are particularly appropriate for that kind of resolution, not criminal matters now. These are civil matters. And they aren't complicated, they aren't complex corporate or business matters. But they're the barking dog problem, maybe questions over land dispute, where the boundary line should go and how a difficulty should be handled in who owns what part of land. It can be done through alternative dispute resolution. There are other improvements to the problems that I've been talking about that haven't been made and need to be made, and you're aware of some of these. For example, we have yet to get the legislature to act on the recommendations of the Judicial Selection Task Force to do away with primary elections do away with political party convention nominations and force candidates for the Supreme Court to be nominated in primaries, just the way all other judges are nominated who run. That would do away with that painful situation and the politicization of the courts that's caused such a lot of criticism. We need the legislature to act on that. We need the legislature to act on the Michigan Campaign Finance Act. It would be simple for the legislature to amend the act to require that money that's spent on judicial elections is disclosed to the public. The amount of the money, the person making the contribution. No big deal. There's tremendous opposition to this, of course, among the people who don't want it to happen. But the legislature could fix that in a hot minute, so to speak, if it was inclined to do it. Likewise, the governor could help a great deal with this business of there being no check and balance on the appointment of judges. We recommended that the governor appoint a commission, a bipartisan commission that functions in the public, interviewing candidates for judge, and makes recommendations in the public to the governor, telling the governor who is qualified for appointment to a judgeship. And that would require the governor, of course, to either pick from among the nominees of this commission or require the commission to come up with a new group of nominees. This is done in many other states. It's the basis of a merit selection system. It's the way appointments are made in merit selection states for the most part. This could be done by a legislative act, it could be done by the Governor's Act. The Secretary of State could help a great deal with voter ignorance and apathy, especially when it comes to judges. Ohio, the Secretary of State in Ohio created a really good voter guide on her website, which is meaningful and gives voters the kind of information voters need in order to choose among candidates for a given judicial office. We've asked the Secretary of State to do this. It wouldn't cost much money, and it could be made available to all voters, all people who go to the polls to vote for judges. We could amend the Constitution, and that's what it would take in order to get away with this age 70 limit. Of all the changes that I've been talking about, the age 70 limit is the only one that's in the Constitution. So the only way to get rid of it is to amend the Constitution. It would take a constitutional amendment to wipe it out, or to add some other limit if needed. That could be done. My guess would be that if we got it on the ballot, people would vote for it, I think. It's just a question of getting it on the ballot. It's not the easiest thing to do. It's an expensive proposition. Well, now, these are some of the big problems that I see in the Michigan court systems. I've given you some of the solutions that we've come up with and that are working pretty well. And I've told you about some that aren't working or that haven't even been tried. I believe that good people in public office and out of office can make a big difference in these improvements being made in the system. I've seen it over the years. It's amazing what a single hardworking person can do. And I know that an organization like the League of Women Voters can have a huge impact in improving government and improving systems that need beefing up. So I commend the League for the work it does and will do in the future. I think that we can't sit on our laurels. We can't wait and hope that things get better in our democracy. We have to be active, proactive in it. Things that are working today may not work tomorrow. We have to be eternally vigilant, I think, in watching to see that what we've got in place stays in place, and then trying to improve what we don't yet have in place. Basically, that's my presentation to you now, and I'd be happy to answer questions if you have any. Yes?
Is there a website or something that citizens can follow to know what cases are before the court?
Yes.
And is there any way for us to give any input?
You can go to the Supreme Court website, and there are other websites as well, like the Michigan State Bar website, and see what cases are coming up for oral argument. The courtrooms are open to the public. You're welcome to go and listen, but you can't express your view on what should happen. That's not in the normal course of events for a judge.
What's the website? What does it say? Like Michigan.gov?
Yeah, Michigan.
Supreme Court or what?
Yes, right.
Oh, okay. Thank you.
Michigan.gov. Yes.
Well, why didn't your commission go the next step and go to a merit-based appointment system for Supreme Court justices altogether?
Well, that's a very good question. Obviously, we discussed it. It was the elephant in the room, if you will. We spent 6 months studying these problems, and I'm convinced that at the end of the 6 months, the majority of the 24 of us really believe we probably should go to a merit selection system and dump the elective system. But we had become so aware of how much resistance there would be and how expensive it would be and how hard it would be, that the majority did not want to vote to do that because they were fearful that the other changes, that the interim changes that could be accomplished in the short run would be smothered. Now, perhaps that's a shame, but the fact is it does appear that Michigan is not ready to jettison its elective system. It's a strange fact that voters go to the polls and don't often know who they're voting for judge, but they don't want to do away with the ability to vote for judge. And maybe one good reason would be they feel that if the judge does turn out to be a real stinker, that they can get in there in the next election and vote him out. That's part of the reason I think.
There's a way to deal with that, of course, and that's through a recall system or a periodic retention vote.
That's right. In fact, almost all the merit selection systems require retention elections. So there's only about 2 states that appoint for life the way the federal judges are appointed. So you're right, a retention election could do that. I just think Michigan is not yet ready for that. And maybe never will be. And I believe that if we could clean up the system with the changes that are recommended by the task force, that it might not be as desirable a step as it is right now to get away from the elective system. No system's perfect. And so the appointed system has its vicissitudes as well. Yes?
Why is it on the ballot, with other offices being voted upon, that the Supreme Court incumbent gets to put under his name current Supreme Court justice or something like that?
Right.
That's kind of a leading, especially for people who aren't really familiar with the issues. They say, oh, he's in, he must know what he's doing. That, vote for him. What's the reason, theory behind that?
It's done because the legislature made it possible. Why did the legislature make it possible? I'm not sure. One argument for it is that if the public are happy, if members of the public are happy with the way the court is running, and they're not quite sure who's in there, the incumbency label will tell them where they ought to go to vote because they want to keep the status quo. And likewise, if they want to get rid of somebody and he's an incumbent, that'll help identify who it is. I don't know that that's a good enough reason.
That doesn't pertain to any other office either.
No,
You know,
you're right.
They could have the same feelings for a legislator or anything. He could say incumbent legislator.
Right, they
But
could.
they don't do that.
That's right, they don't. Now, judges will tell you that they give up their law practice in order to run and sit on the bench, that they don't do it as most terms are 6 years. They don't do it with the idea of spending just 6 years on the bench when they give up their law practice, because it's a big economic sacrifice. And so they will argue entitled to have some help at the polls. And it does help, of course, to have the incumbency label, so that they're likely to be reelected if they're doing a good job, if the public's happy with them, and that encourages people then to take the risk of running for judge. Yes?
You spoke about a number of recommendations made by the task force. I'm wondering if you might be able to speak to which of those recommendations are now being seriously considered and are moving forward in terms of the bodies that might make those decisions.
Good question. Which of the recommendations of the task force are in the hopper right now? The short answer is none of them. The legislature was considering, last I knew, putting before the people a constitutional amendment on the age 70 restriction. But even that I don't think has passed both houses. And in order to pass the recommendations, the legislation behind the recommendations, we really need bipartisan support. And that's what we've not been able to get. And it would be very helpful if the governor would step up to the plate, and the Secretary of State. We've gone before them, the leadership of the task force, and put our case before them and asked them to do it. And so far they haven't seen fit to do it. I'm convinced that if there were enough public outcry about these changes being needed, that they'd look at it again. Yes?
Given the very public low rating of the issue of transparency and in running for office and the funding, in your perspective, where does that big nudge need to come from to move that issue? Because we've seen so many editorials and programs given and letters to the editor. Where does that need to happen to move that issue along towards transparency?
Now, what's going to cause the legislature to act to amend the Michigan Campaign Finance Act? Well, it's an excellent question. The fact is, polls have shown that like 98% of the voting public favors these changes in the law. And yet the legislature doesn't even consider them. I'm not sure what it would take. I do know that when people run for re-election, if they find themselves being questioned sharply about their position on these issues and asked to take a position to make a campaign promise, that they'll sponsor legislation to make these changes, that might work over a period of time.
Okay.
Yes.
Are you in agreement with Justice Weaver that it should be a 14-year term for Supreme Court Justice?
You're asking whether there should be a 14-year term. I think that's Justice Weaver's proposal. That was not one of the recommendations of the task force. It's an interesting recommendation to put it like an age or a term limit on Supreme Court justices. We've never had that. I have mixed feelings about it myself, to tell you the truth. But it is an interesting proposal, particularly to prevent somebody from being in office for such a long time that they become stale. On the other hand, term limits, in my opinion, in the legislature have not worked well. And if that's any if that's any indicator of how it would work on the court, then I would oppose it. Yes.
You mentioned dark money,
Yes.
and in today's Traverse City Record Eagle, there was an editorial, actually came from the Holland Sentinel, about the dark money and how it's impacting on the Supreme Court and the courts in Michigan. And do you see any possibility of any change in the near future?
Well, as I say, there's no movement right now to attack this problem of dark money. But I believe we need to keep it in front of the public and in front of our legislators. Because they are the ones who are the most obvious source to change the situation. I'm convinced that if our legislators knew that we won't elect them again if they won't make these changes, that they'll make the changes. But they have to hear from the voters. You have to believe in yourself, right? And how much you can accomplish. Yes.
But how is that going to happen with gerrymandered districts where a legislator is very safe in his or her job?
Well, he's safe politically because the party, he belongs to the dominant party, right? But what if the members of his or her party are telling him or her they want these changes in the law? Then theoretically that legislator would be willing to vote for those changes, right?
If you can convince the party leadership to do that.
Well, I'm just talking about the electors. I'm talking about the people that the representative or senator has to face in the field when he or she is campaigning again. If this subject keeps coming up and people in the audience keep saying, what's your position on it? And then follow that up with what are you going to do about it? Specifically, don't tell me you think it's a terrible problem. Tell me what you're going to do about it and when.
That's good.
I think that would have an effect, yes.
Has any attempt been made to measure the quality of the justice dispensed by elected state Supreme Courts versus merit-appointed courts?
I've never seen an effort to, well, I've never seen anything convincing that shows that elected judges are better than appointed judges or appointed judges are better than elected judges. It's an extremely subjective evaluation.
There is a ranking, though.
There's a ranking.
That 2008 study by the University of Chicago Law School that ranks Michigan Supreme Court dead last.
Right, and that's, but
it does make note. It goes through 51 courts because Texas has a bifurcated system, and it does make mention of which court is elected and which is appointed, and there is not a tight relationship between the quality of the court as they evaluated it on the three standards and the outcome.
That's accurate, and I think it was because of the extent to which politics seemed to have played a role in the Michigan Supreme Court elections and appointments that the Michigan Supreme Court was ranked so low in that study.
Yes. I do have a question or a comment. The last time I saw you was May 2nd at the Michigan Supreme Court Historical Society meeting when Justice Tom Brennan gave his account. The title of his speech was "The Party is Over." And he wanted both dark money gone and party nominations gone. So Tom Brennan, who is arguably one of the greatest statesmen of the court in recent times, called for this. Your own Betty Weaver certainly has had proposals for a decade about reform of the court, and she's refined those. And at the same time that you convened your group, your study group, and that was led by
Jim Ryan and myself.
yes, but
And Sandra Day O'Connor.
Sandra Day O'Connor, yes, which leads me to, after this was published, you weren't there, but I was in Kent County at the May Day or the Law Day gathering when John Logie delivered the report to all the Kent County attorneys of
John was a member of the task
yes, he
force.
was, and is an outspoken man. And at that point, there were two members, one previous and one current, of the Michigan Supreme Court. Cliff Taylor was there, and Robert Preston Young Jr. was there. And Robert Young was fairly quiet until he was called to the podium. However, Mayor Logie responded to Cliff Taylor's comments describing Sandra Day O'Connor as a fellow traveler. Now, does that bring to mind some of the forces against which court reform must struggle?
It's true that I, for example, spoke before the Michigan Judges Association on Mackinac Island this summer, effectively talking about the task force recommendations, including, of course, the dark money recommendation.
18.4 million in the most recent election.
Right. And Cliff Taylor spoke on the other side.
Yeah.
So he has consistently opposed these changes. And
wants secrecy.
He wants secrecy, and I found it very interesting that the argument I took away that he was making was that this was a freedom of speech issue, and that in order to have freedom of speech, one has to be able to conceal how much one contributes to elections.
Citizens United.
Yes.
But concealing, not just the ability to give, but to conceal who gives and how much from the public. That, to me, that is a non sequitur, to say the least.
Perhaps one of the best reasons that I would urge you to consider a non-merit base for selection of Supreme Court justices is a former governor who rightly controlled the executive branch, but also controlled the legislative branch, and of the judicial branch said, 4 votes. All I need is 4 votes. And how many of those 7 votes had he appointed to the Court of Appeals? Oh, let's see, 4. How many of them did he appoint to the Supreme Court? 3, but the other one he helped elect. So you can have a governor owning the regulation of the state.
It does happen that
It did happen.
it does happen. It did happen that Governor Engler appointed a majority, or appointed plus helped elect the last member of a majority of the court for a period of years. It was an unusual situation, but it's certainly one that could happen again.
We're still dealing with it.
Yes, we are.
I believe it's still going on.
I'm open for other questions, or we can adjourn and enjoy our snacks and talk more.
Thank you, Justice Kelley, for an outstanding talk. We appreciate your taking the time to come to Leelanau County to share your concerns and your solutions to many of these problems. Before you leave, I'd like to tell you about 2 programs we're going to have in November. November 6th, which is our date of our regular league meeting, We're going to have Peter Arnheim, sorry, I have to look at this, who will talk on understanding county government, its structure and authority. I think